welcome to our series of video podcasts 30 Year, 30 Cases, marking the 30th anniversary of the Academy of European Law. My name is Anastasia Pata. I'm a senior lawyer in the private law section of the Academy. In this podcast, we feature a judgment from the year 2000, and more concretely, the case number 220/98, the so-called Estée Lauder or lifting case. This judgment was delivered by the Court of Justice on the 13th of January 2000 and was established itself as a landmark case for European consumer protection. This case between Estée Lauder Cosmetics and the Lancaster Group concerned the misleading name of a cosmetic product, a face cream with the term lifting. The judgment delivered is of far-reaching importance for the notion and concept of the average consumer, especially under the Unfair Commercial Practices Directive. It is now my pleasure to welcome and introduce to you our guest expert, Monika Namislovska. She's a professor of law and head of the Department of European Economic Law at the University of Łódź in Poland. Her main areas of research cover European, German, Polish, private law, particularly IT law and consumer law. She's also a visiting professor in various universities in Germany, Italy, Spain, and Hungary. She's an expert of the Consumer Policy Advisory Group established by the European Commission. Professor Namislovska, thank you for accepting our invitation, and we look forward to your analysis and comments on this important case.
Thank you for having me. I'm very happy to comment on the lifting case for many reasons. The judgment set standards of consumer protection in the European Union. It shaped the legal acts on consumer protection and it influenced the jurisprudence even outside the core acts on consumer law. After 22 years, the judgment is still cited by the court and, for instance, by the European Commission, most recently the guidelines on the Unfair Commercial Practices Directive, which was published in December 2021. But besides the relevance of this judgment, it is also a fun case. The factual background provokes smiles. It is nice to present and easy to remember. The lifting case is the second judgment of the court on consumer protection with Estée Lauder, the cosmetics manufacturer, as the key actor. So it is Estée Lauder who shaped the European consumer law, but it was not an advertorial. Advertorials are prohibited per se as unfair business to consumer commercial practices. Let me start with a short presentation of the first judgment with Estée Lauder as a party, which is closely linked to the lifting judgment because of the products in question, cosmetics, origin of the case, Germany, and legal problem, misleading nature of a name. The Clinique case is an introduction to the reading of the EU law presented by the court in the lifting judgment. The first case was about well-known Clinique cosmetics. According to the producers of competing products, the word Clinique was misleading for the German consumers because of its clinical or medical connotations. Clinique means hospital in German. Estée Lauder was urged to change the labeling of its products and for a period of time sold them under the name Clinique. Eventually, the change turned out to be too costly and the company reverted to the name Clinique. The court found that the connotations were not sufficient to make the analyzed word so misleading that it would justify a prohibition of its use on products, and that the prohibition of its use in Germany did not appear necessary to satisfy the requirements of consumer protection. But it is the second judgment in the lifting case that became the landmark case in the European consumer law. This time, contrary to the Clinique case, it was Estée Lauder who brought proceedings against another company, Lancaster Group. It all started with a face cream manufactured in Monaco and distributed throughout Europe. What was the legal problem? The name of the cream incorporated the term lifting. Under the Cosmetic Products Directive, which was then in force, the names were not to be used in a way that could imply that cosmetic products had characteristics which they did not have. The directive left it to the member states to give effect to this obligation by choosing corresponding measures. In Germany, this obligation was implemented through the prohibition of misleading practices. In the main proceeding, Estée Lauder argued that the term lifting was misleading because it gave consumers the impression that the use of the cream would produce results which were identical or at least comparable to a facelift operation, which was not the case, and that this violated the German law against unfair competition. The defendant, Lancaster, admitted that the cream in question did not have the same long-term effect as surgically achieved lifting, but it had a significant firming effect, and that the public did not expect the results identical to facelifting. Lancaster also claimed that there was no justification for the extra cost that would be involved in adopting a new name for the product if Lancaster had to repackage it for the distribution in Germany. It would cause an increase in prices, and it would be contrary to the principle of free movement of goods. Even back then, the arguments of Estée Lauder were not convincing, but they were supported by national law. They did reflect the approach of the Federal Court of Justice in Germany. In December 1996, so 2 years after Clinique, Bundesgerichtshof held that the finding by lower court that the use of the word lifting was misleading was not incompatible with practical experience, and that it justified a ban on the marketing of the cream if a not insignificant number of consumers, approximately 10 to 15%, was misled by the word lifting. And against this background, the regional court in Cologne, Landgericht Köln, referred the case to the Court of Justice and asked whether the EU law precluded the application of national legislation on unfair competition, which made it possible to prohibit the importation and distribution of a cosmetic product lawfully manufactured and distributed in a member state on the ground that consumers were misled by the word lifting in the name as indicating the lasting effect of the product. The product was being distributed with the same indication of its effect without challenge in other countries within the European Union. The referring court was skeptical about the threshold of 10-15% and suspected that a higher percentage of consumer misled might be necessary to find infringement. The National Court observed, referring to previous judgments of the court, like Mars, that the EU law treats consumer as being both sufficiently alert and sensible, and therefore as not needing protection from claims that might only deceive a small proportion of consumers. The court in Cologne also added that in the absence of a survey of public opinion, it did not have sufficient evidence to reach an opposite conclusion. 4 important conclusions emerge from the judgment of the court. It is the average consumer model that is the benchmark for consumer protection. The average consumer model is the reference point for determining whether a trader's conduct towards consumers is fair or not. The Average consumer was defined by the court as a consumer who is reasonably well informed and reasonably observant and circumspect. In other words, the image of an average consumer defines who is protected. So consumers who are not reasonably well informed and reasonably observant and circumspect are not protected. The second conclusion mitigates this average consumer model, which demands from consumers a fairly high level of knowledge and attention. The court pointed to social, cultural, and linguistic factors, which have to be considered in assessing the impact of the practice on the average consumer. This means that a member state may justify its practices by referring to local, social, cultural, or linguistic features among its consumers, which tend to distinguish them from consumers elsewhere. In the lifting case, these factors could have justified that the English term lifting, used in connection with a firming cream, meant something different to the German consumers than to consumers in other member states. However, the Advocate General finally made two important observations in this regard. As for linguistic factors, he noted that the use of the word did not appear to have given rise to cause for concern in other member states, even those where German is the national or widely spoken language. As for the social and cultural factors, the Advocate General observed that the National Court had not averted to any peculiarities liable to render German consumers more susceptible to being misled by the word lifting than consumers in other member states. Thirdly, the average consumer model is not a statistical approach, but when the National Court experiences particular difficulty in deciding, for instance, whether or not the name at issue is misleading, it may commission a survey of public opinion or an expert opinion in order to determine the percentage of consumers that are misled and to justify or not the prohibition of the practice. And the last conclusion concerns the role of national courts, which was emphasized in the judgment. All in all, in the lifting case, the court held that the EU law provisions on free movement of goods and the Cosmetic Products Directive did not preclude the application of national legislation which prohibited the importation and marketing of cosmetic product whose name incorporated the term lifting. If the National Court decided that an average consumer was misled by the name and believed that the product possessed characteristics which it did not have. So it is for the National Court to decide, having regard to presumed expectations of the average consumer, whether, for instance, the name of a product is misleading. The court sometimes makes suggestions in its rulings as to how to interpret the facts. In the lifting case, it expressed the view that at first sight, the average consumer did not expect a cream whose name incorporated the term lifting to produce enduring effects. And the National Court, the German court, eventually followed this suggestion and did not consider the labeling to be misleading. The judgment of the Court of Justice did not come as a surprise. It builds on previous judgments, but gives a bigger picture and sets a general standard of consumer protection. The judgment has been criticized since it was issued. The main three reasons for criticism are the assumption that the average consumer model refers to a kind of person that does not exist in real life, that the development of the consumer model was not based on any idea of consumer protection. The court only aimed at promoting cross-border trade, so the average consumer standard takes the interest of traders into account, and that the expectations were set high or even too high for consumers. The dispute concerning the word lifting is an extreme example. The claim about the misleading nature of the term was perceived as exaggerated even then. And today, the use of the English word lifting to describe a cream does not impress European consumers. Is it because of the lifting judgment? The answer is only partly positive. It is because of the lifting judgment as regards the German consumers who were overprotected by the German courts. But there are other examples where one can think that perhaps too much is expected of the consumer. But despite criticism, the impact of this judgment is huge. 5 years after the judgment, the standard of consumer protection set by the lifting judgment was introduced in Recital 18 of the Unfair Commercial Practices Directive, which is the most powerful instrument of consumer protection. So the ruling created the standard of consumer protection from unfair commercial practices in all member states. Moreover, the average consumer model is used as a yardstick in the assessment of transparency of contract terms. It applies to food legislation, the conformity of goods, pre-contractual information disclosure. It is also visible in intellectual property law. Based on the Unfair Commercial Practices Directive, the average consumer model may be modified to the average member of a group of consumers when a practice is targeted at a particular group of consumers. The average consumer model does not leave vulnerable consumers unprotected. The Unfair Commercial Practices Directive introduces an alternative standard, the vulnerable consumer model, which seeks to protect the consumer whose characteristics make them particularly vulnerable to an unfair commercial practice or the underlying product because of their mental or physical infirmity, age, credulity, and according to the recent interpretation of the European Commission presented in the new consumer agenda, because of the social circumstances or because of particular characteristics such as gender, digital literacy, or financial situation. In my opinion, nowadays, the EU law needs a new benchmark. The average consumer test, even modified by the vulnerable consumer test, is not fit for the digital age. The time has come to change the yardstick of consumer law to provide a high level of protection against the new challenges that consumers are facing in the digital reality because of the emergence of digital asymmetry that makes consumers particularly vulnerable. The Commission is launching a fitness check of EU consumer law on digital fairness. It will cover basic ideas of consumer law, most probably also the average consumer test and the notion of vulnerable consumer. Depending on its outcome, the final report may be followed by a legislative proposal. I look forward to observing the development of the consumer model and to discussing it at ERA events. Thank you for your attention and a happy 30th anniversary to ERA.